All right, let's dive into a topic that is an absolute goldmine for exam questions. Get this right, and you're banking some seriously easy marks. But get it wrong, you're walking straight into a classic trap that examiners love to set. So let's get started. So, let me throw a classic exam scenario at you. Picture this. A company is going under. All it has left is one valuable machine. Now, Bank A loaned them money against that machine back in January. Bank B also gave them a loan against the very same machine, but in March. The company defaults. Who gets paid first when that machine is sold? Bank A, because they were first in line? What do you think? If you thought Bank A just because they lent the money first, you've just fallen for the trap. The real answer has nothing to do with the date of the loan. It's all about a powerful little concept called a charge, and even more importantly, whether that charge was registered. This is exactly where marks are won and lost, so let's make sure you're on the winning side. Okay, so what exactly is this charge we're talking about? Well, think about it. When a company borrows money, the lender isn't just going to hope for the best, right? They want some security, some kind of guarantee. In the world of company law, that safety net is called a charge. It's the lender's legal claim on the company's property if things go south. Now, here's the official definition from the Act, Section 2, subsection 16. It calls a charge an interest or lien created on the property or assets of a company as security and includes a mortgage. I know, that sounds a bit dense, full of legal jargon, but don't worry, we're going to break it down into plain English right now. Let's just slice this up. A charge is really just four simple things. 1, it's an interest or lien. That's just a fancy way of saying a legal right or claim. 2, that claim is on the company's property or assets. 3, its whole purpose is to be security for a loan. And 4, the law makes it clear that yes, a mortgage counts as a type of charge. So really, a charge is just a lender's legal claim on a company's stuff to make sure they get their money back. Simple as that. All right, let's get to a part of this topic that is an absolute favorite for case studies in the exam. Charges basically come in two main flavors, fixed and floating. And let me tell you, knowing the difference is absolutely critical. First up, we have the fixed charge. And the name really says it all. It's fixed to a specific identifiable asset. We're talking about things that don't change much, like a piece of land, a particular building, or machine number 123. The most important rule here, the company can't just turn around and sell that asset. Nope, the charge has it locked down. They need to get the lender's permission first. A perfect example is taking a loan against your main office building. That building is now under a fixed charge. This visual, it's the perfect way to think about it. A fixed charge is literally like putting a huge, heavy-duty lock on a specific asset. Sure, the company can still use it, they can work in the building, but they can't sell it or get rid of it until that loan is paid off and the lock comes off. Now for its much more dynamic cousin, the floating charge. See, unlike a fixed charge that clamps onto one thing, a floating charge it floats over an entire class of assets. And these are assets that are constantly changing. Think about a company's inventory, its stock and trade, or its debtors. That stuff is always in flux. A company has to be able to sell its stock to make money, right? A floating charge allows for exactly that. It covers all the assets in that class, what's there today and what will be there tomorrow, while letting the company run its business as usual. So let's put them side by side. This slide right here is revision gold. Seriously. For a fixed charge, the asset is specific, and the company's hands are tied when it comes to selling it. For a floating charge, it's a whole class of ever-changing assets, and the company is free to deal with them. One is attached, the other hovers. You absolutely have to know this table for the exam. Now, that floating charge sounds pretty flexible, but you might be wondering, what happens if the company gets into real trouble? Does the charge just float away and leave the lender with nothing? No way. That's where this next crucial concept comes in. It's called crystallization. Crystallization is the exact moment a floating charge stops floating and instantly becomes a fixed charge. The best way to picture it is like a net hovering over a school of fish. As long as the net is hovering, the fish can swim around. But crystallization is when that net suddenly drops, catching all the fish that are in that spot at that very second. The charge that was floating above the assets, it now attaches itself firmly to whatever specific assets are there on that date. So that's the key question, isn't it? A charge doesn't just crystallize out of thin air. Specific events have to happen, and usually they're not good news for the company. So what are these triggers? This is another list you've got to commit to memory. Here they are. A floating charge crystallizes if the company goes into liquidation, or even if it just shuts down and stops doing business. It also happens if the lenders have had enough and decide to enforce their security.
And finally, if the company breaks a key term of the loan agreement. The second any of these things happen, boom, that floating charge becomes fixed. The company can't touch those assets anymore. The lender's rights are now locked in place.
Okay, so we know what a charge is, we know the different types, but none of that really matters unless you make it official. It's not enough to just have it written on a loan document. You have to tell the world about it. And that brings us to the most important procedural part of this whole chapter. Section 77 couldn't be clearer. It says it is the duty of every company to register the details of any charge it creates with the Register of Companies. Notice that word, duty. This isn't a nice-to-have or a suggestion. It is a mandatory, non-negotiable legal requirement. So who's on the hook for this? Well, the primary responsibility lies with the company that's taking the loan. But the law is smart. What if the company just doesn't do it? Section 78 gives the lender, the charge holder, the right to go and register it themselves to protect their own investment. And there's one more special case in Section 79. If you buy a property that already has a charge on it, it becomes your duty to get that charge registered under your company's name. Now pay close attention here, because this is where ICAI loves to ask tricky questions. What's the scope of this rule? It doesn't matter if the property is in India or outside India. It doesn't matter if the charge was created in India or outside India. And here's the big one. It applies to assets that are tangible, like a machine, or otherwise. This word, otherwise, is a huge deal. Don't just skim past it. As your material points out, this one word makes the law incredibly broad. It means this isn't just about physical stuff. It also covers intangible assets, things like patents, copyrights, trademarks. So if a company takes a loan against its brand name or a crucial patent, that charge absolutely has to be registered. This is a common place where students get caught out. And here is a super practical grade A exam tip for you. Sometimes a company gets a loan by just handing over the property papers, the title deeds, to the bank. No big formal mortgage document. A lot of students think, oh, that's informal, it probably doesn't need to be registered. They would be completely wrong. A charge created by a simple deposit of title deeds is still a charge. And yes, it is compulsorily registrable. Do not forget that. Okay, so let's just quickly recap. We've nailed down the definition of a charge, the crucial difference between fixed and floating, what triggers crystallization, and the absolute duty to register. Mastering these basics is the foundation for everything else in this chapter. All right, everyone, let's get into it. So, we've talked all about how to create a charge. That's step one. But what happens after that? Managing the charge through its life, and most importantly, closing it out properly. This is where things can get tricky. It's where students often lose marks, and it's exactly where ICAI loves to lay a few traps for you in the exam. So picture this, right? Your company finally pays off a massive loan. Great news, everyone's celebrating. A few months go by, you're ready to expand, you go to the bank for a new loan, and they say, sorry, can't help you. Why? Because their records show your assets are still tied up with the old loan. How is that even possible? Well, the answer is all in the procedures, and that's exactly what we're going to unpack today. Okay, let's jump right into Section 1. What happens when a charge changes? Because look, a charge is rarely set in stone. Things evolve, and Section 79 tells us exactly how we need to deal with that. So, Section 79 is pretty straightforward. It says that all the rules you learn for registering a new charge, well, they also apply in two other key situations. One, if your company buys a piece of property that already has a charge on it. And two, and this is the big one for us, when you modify the terms of a charge you've already registered. The law basically says a modification is just as big a deal as the original creation. Okay, eyes on this one, because ICAI loves to ask questions about what actually counts as a modification. It's way more than just changing the loan amount. We're talking about varying any of the terms and conditions, changing the credit limits, or even ceding a pari passu charge. Now, pari passu just means on equal footing. So you're basically letting another bank get in line with the first one for the same asset. Even something as simple as changing the interest rate or the repayment schedule is a modification. And here's the one that trips a lot of people up. Even a partial release of an asset from the charge, yep, that's a modification and you have to register it. And here's an easy mark for you, especially in MCQs. Once you've done all that and registered the modification, the ROC will issue a certificate. What's the form number? It's Form CHG3. Remember that, CHG3. That little piece of paper is your proof that you've done everything by the book. All right, so we've handled modifications. Let's move on to the next piece of the puzzle, keeping the records straight.
See, it's not enough to just file the forms. You also have to maintain proper records. And the law is very specific here. It requires not one, but two separate registers of charges.
So let's compare these two. On one hand, you have the registrar's register, which is under Section 81. This is the official one, kept by the ROC on the MCA portal. It's a public document, so basically anyone can look at it if they pay the fee. On the other hand, you've got the company's register, under Section 85. This one is your responsibility. The company maintains it at its registered office using Form CHG-7. And here's the key difference for your exam. Who gets to see it? For the company's own register, your members and creditors can check it out for free. Anyone else has to pay up. Now, this is a classic spot where marks get lost, so listen up. It's about how long you have to keep these documents. The register of charges itself, that Form CHG-7, you have to keep it permanently, like forever. But the instrument of charge, the actual loan document, that only needs to be kept for 8 years after the loan is fully paid off. Permanent for the register, 8 years for the instrument. Do not get those two mixed up. Okay, now we get to the real core of our story. This is the part that explains why that company in our opening example got their new loan application rejected. It's all about what happens after you've paid off the debt. The second you make that final payment, a clock starts ticking. The company is legally required to tell the ROC that the debt is gone, that the charge is satisfied. And your first deadline? Just 30 days. But, okay, what happens if life gets in the way and you miss that 30-day window? Is it game over? Nope. The law gives you a bit of a safety net. You can still file for satisfaction up to 300 days after the payment. The catch? You're going to have to pay extra fees. So the big takeaway here is, don't put it off. Procrastination will literally cost you money.
The whole process makes a lot of sense when you walk through it. First, your company files Form CHG-4. Now, the ROC isn't just going to take your word for it. They'll send a notice to the lender, the charge holder, and say, hey, these guys say they've paid you back. Is that true? The lender then has 14 days to object. If they stay quiet, it's assumed they agree. The ROC then officially records the satisfaction and gives you that golden ticket, the Certificate of Satisfaction in Form CHG-5. That's the document that officially frees up your asset.
And here we go, another classic ICI twist you need to know. There's a shortcut. If you can get the bank, the charge holder, to sign Form CHG-4 with you, you can skip that whole 14-day notice period. The ROC sees the lender's signature and says, okay, they've already confirmed it. No need to send a notice. It's a huge time saver, and it's exactly the kind of practical detail that shows up on exams.
But what if the company just completely drops the ball? They forget to file anything. Is that asset stuck with a charge forever? Not necessarily. Section 83 gives the ROC a kind of superpower. If the registrar gets solid proof from someone that the debt is paid, say the new owner of the property provides evidence, the ROC can actually go ahead and record the satisfaction on its own initiative. It's a really important safety valve built into the law.
All right, so we've covered the happy path, how things are supposed to work. Now let's talk about the other side of the coin. What happens when things go wrong, when rules get broken? Let's talk about penalties and consequences.
This one's a quick but important point under Section 84. If things get so bad that a receiver or manager is appointed to take control of a charged asset, you have to tell the ROC. You've got 30 days to do it using Form CHG-6. And you have to do the same thing when that receiver's job is done. It's all about making sure the public record reflects reality. And now for the penalties. If a company messes up anything in this chapter, whether it's the initial registration, a modification, or reporting the satisfaction, the penalty is hefty. It's a flat 5 lakh rupees.
And they don't just go after the company's bank account. Every single officer who's in default, we're talking directors, company secretaries, they're personally on the hook for 50,000 rupees. The law wants to make sure individuals feel the heat, not just the corporate entity.
And this is a really important distinction to make. There's a huge difference between making a mistake and committing a crime. Those penalties we just talked about, those are for defaults, for messing up the procedure. But if someone intentionally gives false information or knowingly hides something important, well, that's not a mistake anymore. That is fraud. And you're now in the territory of Section 447, which has much, much more severe consequences.
So what if it was a genuine mistake? You honestly forgot, you missed a deadline, you realize there's an error in a form you filed. Is it too late to fix it? Is the damage permanent? The good news is, no. The law has a built-in undo button, a final fix. This is a situation that can cause a lot of panic. You suddenly realize you completely forgot to report the satisfaction of a charge, and it's been way more than 300 days. Or you're reviewing old files and spot a clear mistake in a form from last year. What can you possibly do? Well, the answer you're looking for is in Section 87.
So you can apply for what's called rectification in two main situations. The first, and this is the big one, is when you just missed the deadline for reporting the satisfaction of a charge. The second is a bit of a catch-all. It covers any other omission or misstatement in any of the forms you filed, whether it was for creation, modification, or satisfaction.
And to wrap this up, here are the key details you absolutely have to remember for rectification. First, who do you apply to? The regional director, the RD. What form do you use? Form CHG-8. But, and this is a big but, it's not an automatic approval. You have to convince the RD that your mistake was accidental, or that you had a really good reason for it. And most importantly, you have to prove that your mistake didn't hurt any of your creditors or shareholders. So the big takeaway from all of this, procedure is king. But if you do make an honest mistake, the law provides a path to fix it.